Sam Seder, Majority Report. Pleasure to welcome back to the program Ari Berman, writer from Mother Jones. Do you have any other title there, official title?
National voting correspondent. I got the longest possible title.
National voting correspondent, author.
National voting rights correspondent.
National voting rights correspondent.
Good thing there's no national voting rights news.
And and honestly, I don't know if anybody's written as much about the Voting Rights Act over the past 10 years as you have, and voting rights in general. And we got a couple of things to talk about. We're pre-taping this, and things are moving pretty fast, at least on the gerrymandering perspective. And we will get to gerrymandering, but there's a lot to talk about in the interim. It's also possible, I guess, as we talk about the Voting Rights Act, and that's where I want to start, that over the course of the next couple of weeks, I wouldn't put it past them. I don't know if the Supreme Court is in session. However, we have a question of Section 2 of the Voting Rights Act, and specifically whether private individuals can bring suit or private entities can bring suit on behalf of people whose rights have been dispossessed under the Voting Rights Act, Section 2, whether you can have private action under these things. And there's a lot of reason to believe that the Supreme Court will roll that back. But Ari, will you explain to people all of what I've just said? Particularly, let's go back a little bit. 2013 is the beginning of what very well may be essentially the end of the Voting Rights Act. We have a Supreme Court at that time. It was 5-4. The Chief Justice, John Roberts, cut his teeth in Ronald Reagan's DOJ with basically coming up with ideas how to get rid of the Voting Rights Act. Yeah. And 30 years later, he is in a position to do so. Just walk us through the history of the past 10, 11 years on the Voting Rights Act.
That's right. I mean, there's been this long-standing movement to try to kill the Voting Rights Act, and it's really taken shape and had success once there was this conservative majority on the Supreme Court, led by John Roberts. So the first major blow against the Voting Rights Act came in 2013 in the Shelby County versus Holder decision, when Roberts wrote the majority opinion saying that states with a long history of discrimination no longer needed to approve their voting changes with the federal government. That was really the most important part of the Voting Rights Act, because it stopped abuses before they even occurred in states with a long history of discrimination. So if Texas, for example, wanted to pass a new redistricting map or a new restriction on voting that was racially discriminatory, they had to get that approved from either the Department of Justice or a federal court. And so it was extremely effective. That part of it was basically gutted. Then the other part of the Voting Rights Act—
Let me just say one thing about that is that you had a lot of the conservative justices, I think all of them, say one version or another of, this is a special benefit we're giving to minorities, or you can't hold these people responsible. There's not telling that they're actually going to be discriminatory, even though moments after Shelby County is resolved, you see all of these states go and actually break the Voting Rights Act. That was determined in subsequent cases when we had a motivated DOJ to go after them. They went ahead and did it.
Yeah, exactly. I mean, Roberts' whole argument was basically, he said, things have changed in the South, that the South was dramatically different. The country had changed a lot since 1965, but the Voting Rights Act kept treating the country like it was still 1965, which I think both missed the fact that a lot of the progress made since 1965 was because of the Voting Rights Act, because states tried to discriminate and the Voting Rights Act blocked them from doing so, but also that the Voting Rights Act had been reauthorized 4 times by Congress: in 1975, in 1982, in 1970, and in 2006. So the Congress looked 4 different times and decided, we should reauthorize this. It's still necessary, including in 2006 when the vote was 390 to 33 in the House and 98 to 0 in the Senate. Things that you don't even see ever
Right.
these days. Now, you can't even name a post office with that kind of vote now. So, I mean, there was such an overwhelming bipartisan support for this among the public and in terms of the Congress, and the Supreme Court just pushed all that aside because they had this vision of the country that they wanted to free these states from federal oversight. And then, of course, what happened is you had things like the Texas voter ID law, where you could vote with a gun permit but not a student ID, immediately go into effect. And states like Texas and Alabama and Mississippi and North Carolina all reverting to doing the kinds of discriminatory things that they had previously blocked from doing. So basically, they take one part of the Voting Rights Act, the preclearance part, out. There's another part of the Voting Rights Act, Section 2. It takes effect after, meaning that instead of blocking discrimination before it occurs, you can only challenge things after the fact. But Section 5 of the Voting Rights Act, the preclearance part, only applies to part of the country. Section 2 is nationwide. So that's the really important part of it. And you can still use Section 2 to challenge discriminatory voting laws, to challenge discriminatory election maps, redistricting laws, that kind of thing. Then they start going after Section 2. They weaken it in 2021. They make it easier to be able to pass discriminatory voting laws. Now they're talking about going after it in a few really important ways. One way is what you talked about, not allowing private plaintiffs to file lawsuits under Section 2. That would basically destroy Section 2, because pretty much every voting rights lawsuit is filed by private groups, people like the ACLU or the NAACP. If you said
182, my understanding is that over the past 40 years, there have been 182 successful lawsuits. These are successful ones. There may have been some that failed on the Voting Rights Act. And only 15 of those suits were brought exclusively by the DOJ, because it's a question of, A, do we have a presidency that is interested in allowing everybody to vote? And B, do they have the resources available to pursue this case? So, I mean, that is, I don't know, less than 10% of the successful voting rights cases under Section 2 over the course of the past 40 years have been exclusively the DOJ.
Exactly. So what happens is that basically the federal government doesn't file a lot of voting lawsuits, either because in the case of someone like Trump, they don't want to, or they just are cautious. Even under someone like Biden, they're just cautious about doing this. And private groups are generally more aggressive in filing these lawsuits. So basically, some Republicans and conservatives realize this is the most effective way to kill the Voting Rights Act, is just to say that private groups can't file these lawsuits. This originated before the Eighth Circuit Court of Appeals, which covers 7 states in the Midwest and the Great Plains. There was a redistricting map in Arkansas. There was a redistricting map in North Dakota. And a bunch of conservative judges, some of whom were appointed by Trump, said private groups can't file these lawsuits. So that basically made the Voting Rights Act a dead letter in those 7 states. Now, the Supreme Court has temporarily blocked this. The 3 justices essentially said they would allow this Eighth Circuit decision to move forward. 6 said not so fast, but they're going to hear this case. So that's one major way that Section 2 is being challenged. The other major way, which I know you want to talk about, is this whole question of racial gerrymandering, right? Because
well, I want to start. Let's start with this private action, because you have 182 cases in 40 years that are brought by private actors, or I should say minus 15. So, whatever, 160 some odd cases brought by private actors that win. Never mind, didn't. How do you then, 40 years later, say that this right does not exist?
Well, it's the most wooden sense of textualism, where you say it doesn't explicitly say in the Voting Rights Act that private groups can file these lawsuits. Therefore, we find that it's not inherent in the authority of the Voting Rights Act, which is insane, because from the very minute the Voting Rights Act was passed, private groups were filing these lawsuits. Yeah, the federal government was also filing a lot of lawsuits because they were interested at that point in time in enforcing the Voting Rights Act. But from the very beginning, you had groups like the ACLU and the NAACP Legal Defense Fund and the Lawyers Committee for Civil Rights. I mean, I know a lot of the lawyers back then they worked hand in hand with the Justice Department to file these lawsuits. And then in the years later, when the Justice Department moved on to other things, it was these private groups that filed the bulk of the lawsuits. What happened was you would have places, would have people in places that were being discriminated against. So let's say they want to destroy the only black city council district in a town in Alabama. Those kind of things happened all the time. Those people would approach the ACLU or the NAACP or the Lawyers Committee for Civil Rights, and those groups would bring lawsuits. And that's how it works. So no one even considered the idea that private groups couldn't do this. I mean, it's just one of those things that came totally out of left field, or in this case, right field. And basically, they found some judges to put it into law. And I mean, that's what's happening all over the place with so many different things where these crazy decisions happen, and these judges who would have otherwise never been on the bench, right? Who are even more extreme than the likes of John Roberts or Brett Kavanaugh or Amy Coney Barrett. They're sort of auditioning for the next Trump Supreme Court appointment, and they have these wild decisions, and that's how they get recognized. And so then what happens is, even if the Supreme Court decides not to do this, then you say, oh, they finally did the reasonable thing. But all that does is restore a status quo that no one ever thought about challenging before, Trump came on the scene in the first place.
Right. 4 of those judges appointed by on the active judges on that bench, 4 appointed by Trump, if I'm not mistaken. And I think 4 appointed by George Herbert Walker Bush. And then the first one, George W. Bush. And then 1, or I said 5 by George W. Bush. And then 1 by George Herbert Walker Bush. And 2 by George Herbert Walker Bush. And then 1 during the Obama administration. So, I mean, this is a very Republican court, and tipped over by the Trump people, and also by Gorsuch, I think, sort of floating out there this idea that there is a limited action that private people can take to enforce the laws of their own government, which is absurd. But,
I mean, and we're seeing that in general. We're seeing that in a lot of cases, that even when the conservatives lose, which doesn't usually happen, there's always, generally speaking, a dissent. And then that dissent becomes the basis for a more extreme federal lower court decision, which then gets bounced back to the Supreme Court. And that's what's often happened in these voting cases, is then more extreme things are before the court. Like, this gets to the point that I wanted to make about the other attack on Section 2, which is the idea that Section 2 shouldn't be used to strike down racial gerrymandering. That is also an insane, totally ahistorical idea. Clarence Thomas has basically been arguing this for 30 years. And now it seems like there's a majority on the court for this idea, because they were going to decide, this is the other major attack on Section 2, they were going to decide this Louisiana redistricting case, which seemed pretty straightforward. The idea that Louisiana, which is a third black, should have a second majority black congressional district. The Supreme Court essentially created this situation in another case from Alabama, which said that you should have another second majority black congressional district. So Louisiana was just following what Alabama did. Then, instead of deciding this case after oral arguments this year, they punted it. And they basically said they're going to rehear the case in the fall, and they're going to look at whether this idea of drawing these majority-minority districts violates the Constitution. Another thing that nobody ever contemplated, but now seems to have close or majority support. So that would basically kill the Voting Rights Act, because essentially there would be, even if private groups could file suits, there's no way you're actually going to win any of them.
I mean, just what is the theory behind emanating out of the Voting Rights Act of majority minority districts?
Well, it's essentially the idea. It's basically turning the 14th and 15th Amendment on its head. It's basically saying that laws that were meant to give rights to formerly enslaved people and ultimately to bring a whole huge segment of formerly marginalized and disenfranchised people into the political process, that those laws prohibit the consideration of race. Now, what those laws were meant to do was prohibit racism, not the consideration of race, but they've been turned on its head. And this has been jurisprudence that in a lot of other cases, but it's the interpretation that the 14th and 15th Amendment prohibit any consideration of race, so that creating these majority minority districts therefore would violate the quote unquote colorblind Constitution that was established under the 14th and 15th Amendment, when in fact, the 14th and 15th Amendment were all about giving rights that were previously denied to previously enslaved people. One way you do that is to create these kind of districts that would allow people that were formerly enslaved and marginalized to elect their candidates of choice, which otherwise would be impossible in some cases without the protections of the Voting Rights Act.
Okay, so there's two things here on the Section 2, I guess, rationale is that you could have 40%, just off the top of my head, 40% black population in a given state, and they were gerrymandering these districts in such a way that you would get no black representation in Congress, which you have to literally like take one, if there's 10 districts, we're going to take 1/10 and put it in one district. We're going to take 1/10 and put it in another district, and just create these weird lines that are clearly to disenfranchise black people. So they came up with a formula, essentially, right? Some type of like algorithm that says like, if there's this amount of percentage of black people, Latino people, whatever it is in a state, presumably they should have at least roughly some commensurate political representation.
Yeah, and it wasn't even that. I mean, it wasn't even anything close to proportionality, but the idea was it wasn't necessarily that there was zero, but in places like Alabama, in places like Louisiana, what was happening is there was 6 or 7 congressional districts, and African Americans were 30% or more of the population, but they were only getting one of the districts. And essentially you were packing all of the black voters into one district so that you could dilute their influence in the rest of the state, meaning that the vast majority of districts would not just only be controlled by white people, but white Republicans that were hostile to the views of most black voters in those states. And so what civil rights groups and others showed was that you could create these cohesive districts where blacks were a majority of the population, and they were concentrated in such a way that they could have another district. And this started in Alabama. There's a long history of the court ruling this, but the thing that was surprising was in 2022, the Supreme Court said that Alabama should create a second majority black district, which was surprising because the Supreme Court has been so hostile to voting rights. And it was authored by John Roberts, who has been very hostile to voting rights. And it was joined by Brett Kavanaugh, who's also been very hostile to voting rights. Kavanaugh, though, in that opinion in Alabama, said maybe there should be a limit on how long you can create these kind of districts, which again was kind of shocking because nowhere in the Voting Rights Act does it say there should be a limit. Like the other part of the Voting Rights Act that we talked about earlier, the pre-clearance part, that did have to be reauthorized by Congress. So you could theoretically argue there should be a limit on that at some point in time. But this other part, Section 2, was meant to be permanent. So this idea that there was a limit on it, that was really something only Clarence Thomas had argued. And then suddenly Kavanaugh floats this idea in the Alabama case. It seems like Louisiana is very similar to Alabama, has a cohesive population, has a majority black population, should draw a majority black congressional district. In fact, the Louisiana legislature, which is Republican, already did that. So it seems like this is pretty much settled. And then the court, instead of deciding this case, says, no, we want to look at it again. And we don't just want to look at this instance. We want to look if these districts are protected in the first place. And if they were to do this, it would basically not just kill what was left of the Voting Rights Act, it would basically kill the protections that remain against gerrymandering. Because remember, the Supreme Court has already said you can't challenge partisan gerrymandering in federal courts. That if a place like Texas says, yeah, we're rigging the maps, but we're rigging them because Trump wanted us to do it, and by the way, there's nothing illegal about that, if they can show that they didn't actually discriminate while doing it, which by the way is going to be hard, but if they can show that, the Supreme Court says, okay, we're okay with that. But you could still bring claims under the Voting Rights Act. But if they were to do this, if they were to basically say, you can't challenge partisan gerrymandering and you can't challenge racial gerrymandering, well, then you basically can't challenge gerrymandering at all.
Right. And we should say, getting back to the sort of negative argument against Section 2, it's that like we're supposed to be race blind because of the 13th, 14th, 15th Amendment. And for us to believe that those amendments were race blind in the way that some of these conservatives would argue, it's just a coincidence that it happened in the wake of freeing slaves, right? I mean, it's just like it's a total coincidence that that's what had happened.
Well, the only way you can read them as race blind is because textually they wanted African Americans to have the same rights as whites, right? So it was arguing for a colorblind society, but in the context of giving Black people the same rights as white people. But it was the most race conscious part of the Constitution, and that's what it was specifically meant to do. So there's no way that you can read the 14th and 15th Amendment in a colorblind way to say that it discriminates against whites and advantages Blacks, which is basically what people are arguing in the Louisiana case. This whole district, this whole second majority Black district, is being argued by a group of quote unquote non-African American plaintiffs who are basically saying the Voting Rights Act discriminates against white people, which I think sort of misreads the whole purpose of why there's a Voting Rights Act in the first place.
Okay. So, and we don't really have a sense of what the timing of this is, right? I mean,
well, they're going to re-argue it next term, and they're going to decide it sometime, I would imagine, in the summer. So, months before the midterm elections. And I think it's quite likely that the Supreme Court rejects the private plaintiff argument we were arguing earlier. But I think they're basically just going to say, like, yeah, you can file suits, but they're just going to kill the Voting Rights Act to such an extent that it doesn't matter if you can bring suits, because there'll be no claims that you can functionally win under the Voting Rights Act. That they won't. There will still be a law that says the Voting Rights Act of 1965, but it'll be so toothless as to basically be practically useless. And I think that's just a very hard future to think about. What is America without the Voting Rights Act? Because the Voting Rights Act was a law that basically made America a multiracial democracy. And without it, I think that democracy would suffer in a lot of different ways. And some of the things that we thought we would never see again, those kind of things will start coming back.
And we should just say, just for the sake of clarity, it's not just southern states. There are multiple counties in New York State that are subject to that were subject to the pre-clearance that were, I guess, was reversed. And so we should just be clear on that when we had talked about the pre-clearance earlier.
Yeah, not only that, but I mean, yeah, it covered northern places, it covered western places, it covered southern places, but not only that, I mean, the other part of the Voting Rights Act applies nationwide, right? So, I mean, You could challenge discriminatory voting laws, you could challenge discriminatory election maps anywhere. I mean, it could be Arkansas, it could be North Dakota, it could be New York, it could be Texas. I mean, these laws are filed all around the country. So it really is a nationwide problem. We tend to think of it as one of those things that just applies to the South and just applies to Black people, but it's much bigger than that.
Hey folks, don't forget to hit the subscribe button and check out our daily show. We do it every day at 12 p.m. Eastern for about 2.5 hours. We even take phone calls. You should check that out.